Good evening, Your Honor. I'm Kara Brimmer, counsel for the plaintiffs, Mr. Joyce and Mr. Voigt, and the plaintiffs respectfully request that you deny the respondent's motion to set aside default judgment. My learned colleague first cites Rule 55C of the Federal Rules of Civil Procedure to argue that the court can set aside any default judgment for good cause. However, this rule applies when the court enters a default, not a final default judgment. Here, Your Honor, you've already ruled not just to enter a default, but to enter a final default judgment with the final amount of $1.26 billion. Rule 55 is therefore inapplicable. Opposing counsel also argues that my clients engaged in misconduct when they served the respondents in North Carolina rather than in New York. He would have you believe that because Pepsi was served at its general headquarters and not its legal headquarters, service was not valid. However, under Rule 4H, a plaintiff can serve a corporation by delivering the summons and complaint to a managing or general agent. In this case, the plaintiff correctly served Pepsi at its principal place of business, which is in North Carolina. It's unreasonable to argue that service was invalid. Next, opposing counsel cites Rule 60B to argue that the default judgment should be set aside for mistake and inadvertent error. However, as opposing counsel admits, it was Pepsi who made the mistakes and the errors. My opponent argues that because Pepsi is a multi-billion-dollar company, its board meetings are important, so it wasn't unreasonable for the secretary to forget about the notice and complaint. This is a counterproductive argument, because if the company's billionaire status makes it important, a $1.26 billion lawsuit should have given Pepsi a reason to remember it. Negligent error on the respondent's part should not result in the plaintiffs being stripped of the award that is rightfully theirs. Opposing counsel also uses Rule 60B-6, which states that a default judgment may be set aside for any other reason that justifies relief. Pepsi would have you believe that because the plaintiffs waited 28 years to sue, they shouldn't mind waiting a little longer until Pepsi can get its act together, but this sentiment is not consistent with the law. If Pepsi's employees are the reason Pepsi now faces a $1.26 billion default judgment, then Pepsi can't expect the judicial system to override the standing judgment just because it's not in their favor. Pepsi's attorney next emphasizes the great size of the suit, $1.26 billion, over water, as though that somehow makes the suit frivolous. In this case, we're dealing with a business whose sole product is consumable liquids. The consumable liquid here just happens to be a well-recognized bottled water. This shouldn't impact the default judgment entered in the plaintiff's favor. The plaintiffs therefore respectfully request that this court deny the respondent's motion to set aside default judgment. Thank you, Your Honor.